Hi and welcome. My name is Zach Voorhees. I'm known as the Google Whistleblower. As you know, there has recently been a huge purge of personalities from the YouTube platform for political reasons. We are going to request an emergency injunction to stop this purge. Today, I'm joined here by Cris Armenta, a partner in the law firm Armenta and Soul. She's been a practicing attorney for 25 years. She's been named a top 100 female attorney in California. She's been named a super lawyer in the area of civil litigation and has litigated before with Google in connection with a YouTube video that was blamed on sparking the Benghazi incident. Cris Armenta, welcome.
Thank you. Thanks for having me, Zach.
It's my pleasure. So I want to jump right into it. What is the procedure for trying to reverse this purge that we see on YouTube?
We have seen a huge purge in terms of personalities and channels that were taken off of YouTube last week. And procedurally, it would entail filing a complaint with the relevant court and seeking a temporary restraining order and a preliminary injunction. It would need to be done on an expedited basis. Our understanding is that the speech rights of the channel creators are of significance, in particular significance as the upcoming presidential and general election is approaching. So we would need to expedite the matter and get it on file and try to get a decision from a court as quickly as possible.
Right, so this is going to be, as far as I understand it, filing a complaint on behalf of the content creators that have been purged. Is that correct?
Correct. We've been contacted by a number of content creators who were primarily taken down on Friday, as you know, and it seemed to happen all at once. And it seemed to happen to content creators who did not have previous strikes or who do not have a history of strikes or strikes that would lead to a suspension or termination of the account. It does appear to be that it was politically targeted. Appears that mostly conservative accounts have been targeted for suspension and termination. And it doesn't appear at this point, from what we know, that Google is intending to reverse that decision. So if that's not going to happen, the only way at this point with enough time to reverse that decision would be going to court and seeking an emergency injunctive order, ordering essentially Google to put the content back up so that people have the ability to debate and have information about issues that are of significance as we head into this really significant election.
So I want to ask a little bit about jurisdiction. Is this going to be in a, and I already know the answer to this, but I'm going to ask it for our audience here. Is this going to be in state, or do you think this is something that belongs in the Ninth Circuit?
Okay, well, the jurisdiction issue, so let me talk about the venue issue first. In all the terms of service that people sign on to when they sign on to I'll focus on content creators, so people who own channels with YouTube. The terms of service that YouTube has drafted, or that Google has drafted, essentially say that lawsuits have to be brought in the Northern District of California and in the county where Google and YouTube are located. And so that means geographically, that puts us in the Bay Area. Now, we do have a choice between federal and state court. We could be in state court or we can be in federal court. It really depends on whether there is a jurisdictional hook to be in federal court. The case we're proposing to bring is basically a breach of contract action, so it could live in either court. So right now we have our choice, and those are issues that we're presently evaluating, whether it makes sense and whether, given the composition of the plaintiffs, it makes sense to be in federal or state court. There are pros and cons on both sides.
Gotcha. So what is the time scale, for this?
Well, given that our firm has been researching the issue of Google's censorship since early in the spring, and we've already initiated one case, that addresses some of the issues that we brought in this case. We're pretty up to date on it. We're confident we can get a case on file within a week. And we're cautiously optimistic that that means that we could ask a judge to make a decision very quickly. The goal, of course, being that we want to make sure that the plaintiffs would have a decision in time to get their content back up and be able to disseminate and distribute their news, their commentary, their videos in enough time before the election so that it doesn't feel like their voices are being unfairly suppressed in this important time.
Yeah, an important time it is. I mean, they did this right before the election. Like, for anyone with a reasonable, mindset, this is obviously a political play. And they're doing it almost without any time to respond to this, which is why it's so important that we do this right away. And it's amazing, actually. I want to say that I interviewed a lot of lawyers in order to do this. And Cris and as you'll see in this conversation, she has just done every single angle. And so with that, I want to ask you, what are some of the legal strategies that would give the best chances of success in this injunction?
Okay, well, the simplest and most elegant legal strategy to us appears to be a simple breach of contract case. Every time that a channel creator creates a channel and puts up content, they essentially enter into a contract with Google YouTube. That contract is called the Terms of Service. And Google has amended the Terms of Service from time to time. In fact, in earlier years, back in 2015 or so, the Google Terms of Service, the YouTube Terms of Service said specifically that they could take down content anytime they wanted to for any reason. They had words in those Terms of Service like sole discretion, and we can take it down for any reason, or really, no reason at all. Well, that has changed. The Terms of Service that are in play right now that govern the relationship between everyone who got purged on Friday and YouTube or Google, on the other hand, only provides 3 reasons that YouTube can take down the channel. It's in their Terms of Service, and it's under a heading called Terminations and Suspensions by YouTube for Cause. And what it says, I'm going to read it because it's important. And it's basically what we're going to say is the contract, and this is the contract that YouTube breached, okay? And the language says this: YouTube may suspend or terminate your access, your Google account, or your Google account's access to all or part of the service if you, A, materially or repeatedly breach this agreement, B, we are required to do so to comply with the legal requirement or court order, or C, we believe there's been conduct that creates or could create liability or harm to any user or third-party YouTube or affiliates. So in terms of our legal theory, and it's been an evolving process, but we have learned that in most cases, a simple breach of contract claim against YouTube is one that exists separate and apart from the immunity provisions of Section 230. So what we would say is, by terminating and suspending these Google accounts, these YouTube accounts and channels, that YouTube essentially violated the Terms of Service that it itself drafted. The first one is, did you materially or repeatedly breach this agreement? So there are certainly creators that we know of that either did not have a lot of strikes, or had no strikes, or had 1 strike, or resolved strikes in their favor. So they wouldn't be subject to the reason that they repeatedly violated the agreement, right? The second one is, if YouTube is required to comply with the legal order. Well, we don't know of any legal orders that exist that required YouTube to take down all this content. That's just absurd. Yeah. And then the third one is, if YouTube believes there's been conduct that would create liability or harm to users, third parties, or YouTube or its affiliates. We don't see that as being a basis right now for termination or suspension of these accounts. So what we would do is we would say, look, YouTube clearly breached the contract, the Terms of Service. But that's not the beginning and the end of it. To get an emergency injunction, the standard is that not only do we have to show that it's very clear that YouTube breached the contract, in this case, the terms of service, but also that in the absence of an injunction, irreparable harm would occur. In other words, something really bad would happen, so we need that injunction right now. And in this case, that something bad would be the stifling of the speech. In other words, these channel creators contracted with YouTube as a platform to distribute their speech, right? I mean, that's why people go on there, to distribute your social commentary, your news, your videos, your comments about whatever may be happening in the world. I know last week, one of the things that was most prominent in the news and seems to be somewhat tied to a lot of the purging of these channels is the news that came out about Hunter Biden and so forth. Now, we saw that Twitter reversed itself on censoring out some of the Hunter Biden related news, but it's not clear that YouTube completely reversed itself. Although you can find some content up there concerning the same matter. It may have just been an opportunity to take these folks down. But whether it was political motivated or not, the bottom line is the contract specifies only 3 reasons YouTube can take your channel down. And the question, we believe that YouTube did not meet those standards. So we need to show irreparable harm, meaning that without an injunction, something very serious would happen and you couldn't ever make it better. And so in this case, the fact that the speech will not exist in this arena prior to one of the most important elections of our lifetimes would be that harm. And it's harm that not only is to the content creator who has a right to speak, but it's also harm to all the consumers out there, the members of the public who have a right to hear the speech. Because the First Amendment includes not just the right to say the speech, but also the right to hear the speech. So you've got First Amendment issue concerns from both the content creators and the people who want to view that content and who use that content to inform themselves for better or for worse. They may agree or disagree with the content, but it's part of a robust debate that the country is engaged in.
Right. I've got a follow-up question, which is, let's say that a content creator on YouTube uploads a video on 2012, and then they do another video in 2020, and the terms of service update. For that first video in 2012, does it get grandfathered into the original terms and service when it got uploaded, or does everything roll into whatever terms and service that Google and YouTube decide need to apply now?
That's a good question. I think that the most obvious interpretation is that because Google's terms and service says that they can update them anytime they want, and that your continued use of the service means that you're subjecting yourself to the new amended terms of service. I think it means that you keep moving along every time you upload something or you have old stuff uploaded, you're subjecting yourself to the new terms of service. So I would think that all the videos that were purged on Friday and the channels that were purged on Friday would be subjected to these new terms of service. But frankly, I mean, they're more restrictive terms of service than YouTube used to have. YouTube used to have terms of service that would have allowed them to take anything down at any time. And for some reason, they amended their terms of service and imposed a restriction on themselves, saying that they would only terminate or suspend accounts for these 3 specific reasons, which it doesn't appear exist in this case.
Why would they do that?
Oh, it's a good question. I mean, I don't know. I have some guesses and some speculations, maybe to make themselves more palatable to the public, maybe to be able to keep content up that people were asking them to take down and to be able to point to these terms of service. I mean, we had an experience back in 2012 where we brought a case on behalf of an actress who had unwittingly appeared in a movie, a YouTube video sensation for a minute called The Innocence of Muslims. You might recall that The Innocence of Muslims was that short video that was put out by a guy named Nakula, and that was blamed later on sparking the protests and the incident in Benghazi that led to the death of 4 Americans. And in that case, we represented an actress, and the actress had no idea that she was acting in this kind of film, and words were dubbed over her mouth, making it seem like she called Muhammad a pedophile. People wanted to kill her because of this around the world. So we actually filed a case and initially got an injunction to take down the content. And we forced Google initially to take the content down. And Google's answer to us at that time, they refused to take the video down, was that the answer to bad speech, in this case, blasphemy of Muhammad, was more speech. The answer to bad speech is more speech. But Google appears
Wait a minute, who said that? Who said that?
Eric Schmidt said that, who was the CEO of Google at the time. So at the time when we wanted to take it down, and actually it was interesting, the chief judge at the Ninth Circuit at that time asked the Google lawyer, why don't you just do the right thing and take it down? You can see the kind of consternation this video is causing around the world. Google refused to take it down. They fought us in court. It was a very robust fight, I will say, with a lot of lawyers and a lot of people involved in it. We had hooked on to a fairly obscure theory concerning the performance rights of our client and not having someone dub over her performance without her consent. Ultimately, the Ninth Circuit rejected that theory on the copyright claim, but it was really interesting because Google resisted so much taking that video down. And I don't know if the new terms of service, which restricted their ability to take things down, were a result of that case. I mean, timeline sequencing, it seems like it's possible. But the bottom line is that once upon a time, Google used to say, and Eric Schmidt said, the answer to bad speech is more speech. And now it seems it's the opposite. The answer to bad speech is scrub it off the internet.
Wow, that's incredible how far they've come in just a few years. So what about, Section 230? Isn't big tech immune from lawsuits because of this?
Good question. So Section 230 does protect Google from liability for, in this instance, as an example, they would say for blocking or filtering content. And Congress gave social media, big tech, ISPs, the ability to have that immunity so that they could, without penalty, take down content that was filthy, obscene. And it was really designed to combat the issue of child pornography and that kind of harmful content. Unfortunately, over the last 24 years since this section of the act was enacted, big tech has seized on that language, that immunity language, to make it seem broader than Congress really intended. In other words, say we can take down anything for any reason. And believe it or not, there are courts across the nation that have actually grabbed onto that idea and allowed big tech to exploit that language to allow them to take down anything you want, even though the deal that was made in Congress and the clear congressional intent shows that it was only designed to take down lewd, lascivious, filthy, the kinds of things that are obscenity that are not necessarily protected by the First Amendment. It had this catch-all provision. It said you could take down this kind of content or other objectionable content. Now, some courts have interpreted that provision to mean that, oh, well, Google itself can determine what's objectionable. If they don't like your red tie and they think it's objectionable, they can take it down. But interestingly, in the circuit, the Federal Court of Appeals circuit in which this case is likely to live within the Ninth Circuit, that language has been pared back a little bit. There was a case that was decided in 2019 called Enigma, and the three-member panel of the federal court said that no, the immunity that has traditionally been thought of under Section 230 as widespread and sweeping and limitless is actually not boundless. There are limits to that immunity. And it actually has to be something along the lines of filthy, lewd, lascivious, and so forth. It can't just be because we don't like it or because we don't like your viewpoint. In this case, the bad reason they wanted to take down the content, it was an anti-competitive thing that happened in Enigma. That case is really interesting. We've been watching it, and there was a petition for cert filed before the Supreme Court. And just last Tuesday, the Supreme Court denied cert, which means they're not taking the case, which means the law as it stands in the Ninth Circuit right now, at this moment, basically as of last Tuesday, is that big tech's immunity in the Ninth Circuit is not boundless under Section 230. We don't necessarily think that Section 230 is implicated in a straight breach of contract action, but if it comes up, we've got Enigma.
Can you tell me a little bit more about Enigma?
Yeah, Enigma was a case where content was taken down, and the reason it was taken down was for anti-competitive reasons. And the Ninth Circuit said that's not in keeping with the spirit of the statute, when the spirit of the statute was to take down a list of things, basically things that looked like child porn, lewd, lascivious, filthy, and the like. The Congress never said anything about taking content down just because you don't like it, or because your advertisers don't like it, or because politicians are putting pressure on you to take it down because they've deemed it false or harmful or fake news or disinformation. That wasn't part of what Congress said. But what's interesting about that, and if you compare that with the hearings that occurred last week on the Hill in connection with the nomination of Judge Amy Coney Barrett, if there was a decision that Section 230 immunity should be viewed as broadly as big tech wants it to seem, that decision is one made in Congress. That's the decision that the House and the Senate should make. That's never been made by the House and Senate. In fact, they haven't revisited the statute, in 2 decades. The Supreme Court has never made a ruling on Section 230. If you read Justice Thomas's opinion as of Tuesday, when cert was denied on the Enigma case, he said in 24 years, we've never had a chance to look at Section 230 and decide whether the immunities are as broad as big tech is holding them out to be. But I do think what's important about the Enigma case, to answer your question, is that Enigma is the first case where the Ninth Circuit pretty decisively said, we're not going to let big tech getting away with saying that you're immune for everything all the time. There are going to be limits to that. They said the limits are not boundless. And we think that this case that we're talking about bringing with respect to the purge, if 230 comes up, would fit right in that.
So can you define perhaps some of the limits, or did they sort of just leave it as vague?
So basically what the Ninth Circuit said is, when you look at the language of the statute, let me find the language of the statute. When you look at the language of the statute, and that gave them immunity for taking down content, right? So they were told there's two parts of the ISP immunities. One, if you put content up, they're not responsible for that. In other words, they're just a conduit. They're just a street corner, okay? So they're not responsible for your content. So if you put up content, you defame someone, that's on you. That's not on them. That's sort of the conduit theory. The other part of that is if they take your content down. And what it says is that they're not responsible. The statute says they're not responsible for taking down material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. And some of the circuits have said, oh, that means you can take down anything. But the Ninth Circuit says no. When you make a list like that, obscene, lewd, lascivious, filthy, excessively violent, and then you say, or otherwise objectionable, the otherwise objectionable isn't a free-for-all. It has to be of the same type.
Right, like they're using it as a catch-all. They're like, oh, it can just mean whatever the heck we want it to be. Like, hey, this is got a purple background, so it's objectionable to our corporate culture, so it's out.
Exactly. And what the Ninth Circuit says is, no, it's got to be the kind of the same thing. It's got to be of the same kind. And so, and then there's the other thing is that they also, we would argue that you have to have good faith to take it down. So they have to take it down based on, a good faith reason. And that taking it down just because they don't like your political viewpoint is not a good faith reason. And it has to be sort of the language of the statute. It's kind of like a Good Samaritan statute, like they're taking it down for a good and benevolent reason. Maybe they would argue that taking down this content is good and benevolent because the content is so dangerous and harmful, but I'd love for them to say that.
I think that the answer to bad speech is more free speech.
Yeah, I agree.
I think Eric Schmidt had it right when he said it back in the day. And it's really surprising that he's gone full 180-degree change on that. So here's my next question. There is a government pressure to censor. And I was wondering if you think that Google might be a quasi-state actor.
Oh, I don't even know that I would say quasi-state actor. We've alleged in another case that we have in representing young Pharaoh in connection with his demonetization. We actually think that Google has acted exactly like a state actor and should be held liable just like a state actor. Now, the state action and First Amendment may not fit squarely in this case. We're talking about the October purge because I think the proper thing to do is bring a straight up breach of contract case. But I will tell you that Google has done things in ways that they should be responsible just as if they were a state actor. And let me explain. Back in 2019, Representative Adam Schiff wrote a letter to, let me find the letter here, wrote a letter to Sundar Pichai, Chief Executive Officer of Google, on February 14th, 2019. And that was a letter written on congressional letterhead by one of the most powerful members of the House and of Congress. And it was a 2-page letter, very dense, which talked about the problems that Representative Schiff perceived there to be about dissemination of unfounded theories about dangers of vaccinations. In that letter, he put forth his position that basically Facebook, YouTube, and the like should not allow there to be speech about the other side of the viewpoint on vaccines, that they might be harmful or that they're not a good idea or for whatever reason. As we know, there's a robust debate on these issues. And they've always been out in the open. They've always been debated. But in 2019, that signaled a pretty big departure from people embracing free speech, and it went to, let's just not have the speech at all. So in 2019, that's the letter that Representative Schiff wrote. He also said that they didn't want to have any conspiracy theories. He didn't want any medically inaccurate videos. He didn't want there to be any vaccine misinformation. And he wrote
what's the source of truth, though? Because, if you're going to say, well, we don't want anything like medically inaccurate, well, there has to be like a source of truth. And it seems that in this day and age that the sources of truth are selective.
Well, look, that's the whole debate in this country, right? Like, everyone has a different point of view. People say follow the science, but what's the science? The science is all over the place. The truth is all over the place. Everyone has their own truth. And the beautiful thing about this country is I thought we were the kind of country and a value that we all held dear is that we would be able to have an open and honest and robust debate, even if we have differing viewpoints. I think Voltaire put it well, to paraphrase him, when I might not agree with your speech, but I'll fight to the death for your right to say it. You look at the case, the old case that some people love and people hate, the burning flag case. In Texas v. Johnson, the Supreme Court said, I may not like that you burn the flag, but it is a political expression, and we're going to protect that right. If you think about, our veterans and some who unfortunately did not come back from combat and, fought to protect the freedoms that are in our Bill of Rights and the right to be free in this country, I think it's a dishonor to them when we're not standing up for free speech. And it makes me wonder, who does get to be the arbiter of the truth? Apparently, Representative Schiff thinks that he is the arbiter of the truth, and he's actually imposed on Google that they should help him in that endeavor. There's another letter that he wrote again on congressional letterhead on, this one is more recent, April 29th, 2020. This was during the pandemic. And in that letter, Representative Schiff urged Google to literally censor out content that he deemed harmful if it went or contradicted the World Health Organization. I mean, we already know how controversial the World Health Organization has been. But on April 29th, Adam Schiff said, if there is content on YouTube that contradicts the WHO, I want it off of YouTube. And let me just read this from his letter because it's fascinating. It's very strong. I'm not just saying this. Here's the letter published on his congressional website, on congressional letterhead, and then tweeted out to the CEO of Google, Susan Wojcicki. And what the letter says is, after he talks about he wants them to remove or limit content that promotes harmful medical information. He says, though the best protection is removing or downgrading harmful content before users engage with it, that is not always possible. He wants the users to, he wanted Google to display messages to users who have engaged with harmful coronavirus-related information. He wants them to remove information, and he wants them to connect them with the WHO organization instead of the speech which they might have been watching or listening to. I mean, I think it's stunning that we have one of those powerful members of Congress reaching out to a private company on congressional letterhead and telling them how to run their business. And not only,
go ahead.
Let me just add this. Not only did he tell them how to run their business, but he then tweeted this letter to the CEO of YouTube, and she then responded in a tweet on the same day and said, "Thanks for reaching out. We're working every day to protect people from misinformation, to help them find authoritative information. We appreciate your partnership and will continue to consult with members of Congress." So she actually acquiesced and said, thanks, Representative Schiff. We're going to basically do what you say in a partnership with you. So to me, that removes from Google any notion that they're just acting as a private party and exercising their own First Amendment rights, because they're basically doing the bidding of one member of Congress who wants it his way.
I mean, it's incredible because, I mean, they're asking Google to censor using automated tools, which is essentially artificial intelligence. Like, that's what I blew the whistle on, was this like machine learning fairness that was data mining all the videos and then classifying them as certain types of speech. So they write a classifier and they could run it that says, hey, this video contradicts the WHO. I mean, it's not even a human censor. What he's asking for is the ushering in of an AI technocracy that's going to sit between what you can say and what can be broadcasted. And it's just like, for someone else, it's just like, oh, he's just asking for speech. It's like, we have to realize that this is way worse than just a censor. Like, at least with a censor, you have normally like a human being. But an AI that is unappealable, you don't know how it works. Its brain is made up of this network of simulated neurons that's deciding like what you can and cannot say. This is really scary stuff. And the fact that it comes from the government itself on an official letterhead, is proof that Google has gone from, a private corporation into a partnership with the government to figure out what is true and what is not. And this is something that the Constitution has clearly forbade from happening, but, they don't care. They just want to do that, and
stunning. Yeah.
Stunning. It's
astonishing that we're actually living in such an Orwellian situation. Yeah, it's really hard to believe. But you know what? I'll tell you this. I do think that if the case was to get to the Supreme Court, um, I think it's either fixable at the congressional level or at the judicial level. I mean, ultimately, there has to be some kind of a congressional fix to the mess that 230 has become. And I don't think that was Congress's intent initially, but it has been twisted and broadened. But the Supreme Court has previously visited the issue of when a private party like Google, that's my dog, sorry, starts acting like a state actor. There's a really old case called Blum versus Uretsky. And in that case, the Supreme Court said, when a government encourages or coerces a private party to behave in a particular way, it's just as good as the private party being a member of the government.
Yeah.
So, and then therefore they're subject to the protections contained in the Bill of Rights, like the First Amendment. Like, example, suppose a police officer comes to your door and without a warrant and knocks down your door without a warrant. Clear Fourth Amendment violation if there's no exigent circumstance. New scenario. Police officer comes to your door but makes your neighbor knock on the door, right?
Yes.
And holds a gun to your neighbor's head, and your neighbor knocks down your door and comes in your house without a warrant. It's still state action because the government is coercing or encouraging that private actor to act like in a state-like matter. So same rule applies here. If Representative Schiff is forcing, coercing, or encouraging Google to behave in a certain way to violate First Amendment rights, there's your First Amendment violation. It's as good as holding the officer holding a gun to the person's head. So I think that if we get to the state action issue, which we may not necessarily get to in this particular case, but I think it is important to know that this is not necessarily novel ground. I mean, if there is Supreme Court precedent that says that if a private party is encouraged by a government actor, it becomes government action, boom, First Amendment applies.
You know, and it's funny how they just, with the flick of a pen, they write a letter that encourages the destruction of the First Amendment with Google. And, you know, this First Amendment has been fought for and has been paid for by the lives of our military and their families and the sacrifices that they've given to this country. And, you know, you've had some military service. Your dad was a Marine, still is a Marine. Once a Marine, always a Marine. What can you talk about, you know, in terms of that and, you know, the Bill of Rights?
I have never been in the military, but many members of my family have served Marine Corps, Navy, and I think that when I look at the members of my family who have given so much of themselves, and I think about how hard they fought to protect our freedoms, and not just members of my family, but American soldiers, you know, across our country, and the families who have given, you know, the ultimate sacrifices. It's a real dishonor for us not to be standing up for the Bill of Rights. But I'll say, how about just the First Amendment for now? I mean, we can move on to the second later, but this is the First Amendment issue, I think. It may not be, like I said, it may not necessarily come up in this particular case because I think we can phrase it as a straight breach of contract action, but the First Amendment issues will not necessarily be lost on a judge because that's where comes our irreparable harm. I mean, if we don't get an injunction, then people are not going to be able to give their speech and hear their speech. And I think that I hope that every American would agree that the First Amendment is particularly right before an election is important enough that we ought to do something about it.
Yes, and it's very important that that we do so because we're at the 11th hour. We really are. Like, we either stop this or you know, with this purge that's happened on YouTube, and I expect there's going to be more purges that are coming. You know, we're really at the precipice. Either we defend the Constitution and what this country stands for, or we lose it and something else will come in the way. Because, the future, there's a divergent path. We have this path where the Bill of Rights is protected, the First Amendment stays on, or we can go into this tech AI censorship where what's true and what's not is defined by some mystery, algorithm that we don't have insight into, and we don't have the ability to change via an election. Like, think about this. Like, Google's algorithms are being decided by a secret group of people that are unaccountable to anything that you or I have as a citizen. We can't vote to change how Google is going to censor on its own. And so this is a real problem. And I really do believe that right now we are at the cusp of, either preserving the freedoms that we've enjoyed for our children and our children's children and for the children to come, or we lose it all. And, that's really what is at stake now. And so, Cris, I think we should end it on that. I think that you are an American hero. And thank you for, going through, step by step what the process is and what's at stake, and sort of the legal swords that, can be used as this case progresses. Is there anything else that you want to add?
The only thing that I would add is just briefly is that when we were talking about how stunning it was that it was placed on a letter, I think it's important to note that the power of the Congress to influence private parties is enormous. Not only does it come in this case in the terms of a letter on congressional letterhead, which you can imagine is pretty imposing and pretty threatening, but Congress has a power to subpoena. I mean, we saw that the big tech has been called up to the Hill next week. They're not checking on anybody's schedules. They need to get to the Hill and start testifying about the specific issue about censorship. So it comes in all kinds of ways: political pressure, government pressure on private parties. It doesn't necessarily have to be a law that's passed, a regulation that's passed, or just a simple letter by Adam Schiff, but there are an enormous and countless amount of ways that I have to believe that there's been pressure applied to big tech. The other one that could happen is the threat of legislation. In other words, act the way you want me to act, or we will legislate out your Section 230 immunity. That is certainly a threat. But as we go forward, I think we're really looking forward to the opportunity to see if we can reverse the purge quickly in this case, using the simple yet, we hope, elegant breach of contract theory and all the research we've been doing through the past few months on this issue. Ultimately, while there may be a decision available in the courts here and now, my personal view is that Congress needs to take up Section 230 and tell the courts exactly how wide a big tech immunity should be, because it has been abused and it does need to be stopped.
Cris Armenta, everyone. She's a firecracker and she knows her stuff, and she is the perfect person for this case. And I'm so glad that I found you. You can find her. What's the website that people can find you on?
Our firm website is www.CrisArmenta, CrisArmenta.com.
All right. Well, thank you very much. And I hope you guys enjoyed that. If you have any comments, please let us know what they are. If you have any questions that are burning in your mind, reach out to us and let us know what they are. And we're going to read the comments and see what it is that you guys think, because maybe there's some of you out there that has a great idea that we haven't thought of yet. And so just let us know. All right. Well, thank you very much.
Thank you.
Bye.
Bye.